Remember, I covered pitch theft in an educational video about 2 weeks ago on my IG page. Go to Ownership Attorney and look at my IG page for pitch theft. Well, here it is, a recent situation that is an example of not doing all the things. I was going to make this recent situation a legal lesson segment, but I just want to talk to you. I just want to talk to you informally about this, because when will we decide to move in a way that puts us in the best position possible, right? I get it that even with legal, even with doing some of the things, you may not be able to prevent foolish people from doing foolish things. I get it. But you can put yourself in a position to give those fools a fool's prize if they test you. So doing all the things you need to do always puts you in a better power position. If you're going to be dealing in any industry, you need to be in a power position. You need to come from that way. So Lauren Salkin, who is a writer and an entertainment journalist, just filed a copyright infringement suit on August 21st. She filed this suit against Taylor Sheridan, Paramount, NBC Universal, 101 Studios, and Elevate Entertainment, which is the management company of Taylor. She says in her claim that she spent more than a decade developing a series called Sovereign Nation. She took this decade-long series that she put her blood, sweat, and tears into and submitted a completed pilot, series Bible, and a pitch deck to Sheridan's representatives. She submitted it, according to the claim, it was like late 16, early 2017, but she had already registered the work with the U.S. Copyright Office, and she did this, in 2017 or before anything actually happened. Because on February 1st, 2017, she received a note saying, well, thank you for your interest, Taylor. Thank you for submitting all this and your interest. Thank you for submitting your interest to Taylor. But Taylor is unavailable for any TV projects right now. She let it go. Within months, Paramount greenlit Yellowstone, which premiered in June 2018. And it became a very popular franchise in television. In her claim or her complaint, she is definitely careful to note that she concedes to the fact that copyright does not protect the abstract ideals of the story, because copyright doesn't do that. They don't protect ideals, and they don't protect things that are abstract, things that other people can use. You can't just have a red balloon and think no one can use red balloon, like Pennywise. But what she did state is that the infringement lies in the copying of her particular expressive choices and the way that she coordinated selections and arrangements of those abstract ideals, of these non-copyrightable elements, if you will. And that's when something does become copyrightable. It has to be a unique expression, unique authorship of ideals. Hence this lawsuit. Being that copyright only protects what survives the filter, a court is going to put that copyrighted work through a test. They do what's called an extrinsic, intrinsic test, and they're going to filter it. When they administer this test to determine what stands, they're going to look at if there's enough protectable elements to stand. If it's not enough protectable elements to stand, how were they woven together? And if they're woven together and they're possibly protectable, is there what they call substantial similarity? So there's a lot that goes on with copyright. If they don't find either, she's not going to prevail. When it comes to copyrighted work, especially scripts, there is another layer of protection that should always follow. Anytime you're sharing or you're so-called pitching, you need to make sure you follow all layers of protection and done correctly. In this case, the second layer that could have helped if copyright infringement fails is barred by the statute of limitations. So that's another thing. And that's probably why it wasn't raised in the claim, that second layer of protection, which is implied contract or an actual one. If the second layer is used, it is done correctly, it is curated, drafted correctly, and it is raised on time, That may be the difference between prevailing and losing a copyright infringement. You know, I write about this in my book, Code v. Code. It is available on Amazon in hard copy. It is on audio. It's available iTunes. And if you want a signed copy with a note from me, you can order it on my website, ownershipattorney.com. But I write about this in the book. And there is actually a section in the copyright chapter. There's actually a section in here where I'm talking about story theft. It says story theft. And one of the things I bring up is the fact that fighting a story theft case in court is already problematic. Therefore, it is best to create a scenario that gives you a fighting chance. By registering federal copyright in your work, you will gain the expanded benefits provided under the law, which you have to register your work to even bring a copyright infringement into the court. But creating and disseminating a written agreement stating what the intentions for sharing are and what the expectations are if the story is used increases your protection. I go on to explain how and why. It is important to know all layers of protection because as legal, when we go into a court, we're looking for as many claims as we possibly can throw to see which ones stick, because if one fail, another may prevail. But when we narrow that argument or we narrow that fight, then the chances of winning also narrows. In addition to my book, I do have a course that I'm launching in January 2028, end of January. I'm launching the Onorati Academy. The Onoratis are my tribe who own what they build or invest in learning how to do so because they're tired of being tired and sick and tired of being tired. And the Academy is virtual. It's a virtual 14-week master class where I am teaching creatives, streamers, founders, sport professionals, athletes, entertainers, very important lessons that can help them protect their rights and to stop leaving money on the table or stop giving away money and rights, but to level up ownership. The waitlist is now open. I opened the waitlist last week. You can go to ownershipattorney.com and look at the Onorati Institute page. You'll see the Onorati Academy. You can sign your name up on the wait list. Once you join the list, you will get all of the details about the masterclass and what to expect. It's time to start repositioning ourselves and stop trying to move in a way where we think this is a great relationship. We're friends. We're buddies. I trust it. I just want that opportunity. I'm desperate. I need a breakthrough.